Welcome to Trigger the Truth with attorney Jason Guida, where we unravel the ins and outs of Massachusetts firearms law.
Welcome to Trigger the Truth, Massachusetts Firearms Laws and Policy with attorney Jason Guida. I'm excited to talk to Jason today because we're going to just jump in and ask this first question to you, Jason. How hard is it to obtain a firearms license in Massachusetts?
It can be a difficult process depending on your background. If you're a guy or a woman that hasn't had any encounters with law enforcement, hasn't had any issues, domestic issues or mental health issues or substance abuse issues, well, maybe it's not that difficult other than, jumping through the hurdles or jumping through the hoops to get that application together and doing what the police department requires of you. Now, if you are a guy that, like many of my client base, that you might, have a few scratches and dents, then it can be significantly more difficult. Massachusetts has one of the strictest licensing schemes in the United States, and it starts with disqualifiers. So we prohibit the issuance of licenses to people who fall in a significant number of categories, not just felonies, not just committed for mental health, but, certain misdemeanor crimes, drug crimes, any weapons crimes. Most recently, we've added harassment prevention orders, which are basically non-domestic orders. Restraining orders obviously are domestic, but harassment prevention orders is a fight between you and a neighbor where the neighbor feels threatened and gets an order from a court to tell you to leave them alone. That now prohibits you from getting a gun license. So from the prohibiting factor standard, it's pretty in-depth and can be problematic if you have an old case on your record or some sort of issue going on currently with your neighbor. What really makes it hard is the suitable person standard. The suitable person standard is the chief's power, his discretion, your local police chief, to say no to you, to say, no, I'm not giving you a license. You're not prohibited, but I'm not giving it to you because of some sort of behavior or conduct that you engaged in at some period of time. That is, quite frankly, not necessarily unique to Massachusetts, but one of the hardest things for people in Massachusetts to understand and to oftentimes get over the suitability hurdle.
I know that you're quite involved with other organizations. I know, having dealt with firearms laws for as long as you have, it's apparent that you'd have an opinion one way or another about why laws are the way they are. Should they stay that same way? But tell me more about how your involvement with representing your clients in these firearms laws cases, how has that affected your perspective on Massachusetts laws in general?
Sure. So I've had the unique experience of actually being on both sides of firearms licensing cases. So when I worked for the Commonwealth, when I was the director of the Firearms Records Bureau, it was my job to determine suitability on non-residents, people who live outside of Mass that were trying to get Mass licenses. And I would deny licenses based on suitable person standards, things that people were engaged in, certain criminal activities or issues that didn't result in convictions, but would lead me to believe that that person may be unsafe with a firearm. And I've litigated those cases on that side. And now from the other side, I understand what law enforcement is thinking and seeing when they see a record that, it may not be convictions. You may not have, been found guilty. You may not have gone to jail. The charges may have been dismissed. But I understand how the police are looking at it. To your point, in some situations, sometimes suitability makes sense. And I think most law-abiding gun owners would look at this and say, look, this guy has had, 6 times in the last year, he's been charged and arrested for assaulting his wife. And every time the case gets dismissed because his wife won't testify. But maybe he's a guy that maybe shouldn't have a gun because he might hurt his wife. But then on the other side of it, you see guys that had a crime 30 years ago that got dismissed. And the police chief will say no. And you'll be scratching your head and say, why? Why are we letting this happen? What's particularly frustrating is the limited options that you have when you're denied. And really getting into that, you have a right to what they call judicial review when a chief denies your license because he believes you're unsuitable. Judicial review, what I tell my clients, is not an appeal. You think of an appeal, you think of what you see on TV on, the People's Court, where you get to say your side of it. You're a good guy. Your mom's here in court. You're wearing a shirt and tie. Come on, judge, you should get the license. That is not what this is. The judge's role in judicial review is to simply look at the reason the chief used to deny you. If that reason is reasonably credible, reliable, and it has some sort of connection to a risk to public safety, a possible risk that you might harm yourself or others, the judge is required to uphold the chief. So your due process rights are limited at best. Those are some of the suitability cases are some of the hardest cases that I do for clients. I'm very selective with my cases because I know how hard it is to overcome a chief's discretion.
Is there really a way to challenge that? Because I'm sure for a lot of people who may find themselves in that position or just thinking through that, it may be easier just to throw your hands in the air and say, well, I guess the law is what it is, and I'm not going to even try to obtain a firearm legally if I want to.
There is, and I've had success doing it. Like I said, I'm very selective. I want to take cases that I think I can get good results. Really, I mentioned it has to be reliable and credible information. So that's really your two-prong attack. Credibility, right? So somebody says that you did something. You say you didn't. Well, it's kind of the liar, liar, pants on fire defense. If you can produce the evidence to prove that you didn't do it, because as the law stands right now, the burden of proof is on you. If you can prove you didn't do this thing, well, then that information is not credible. That's a hard thing to do oftentimes, particularly when you have a he said, she said type scenario and there's no witnesses. But sometimes you have witnesses. And sometimes you have, people recanting their story. And in those cases, you can certainly go at it from the credibility prong. The other prong that I attack on is the reliability prong. So reliability, in my opinion, is about predictability. How do we know that this thing that they're alleging you did, and maybe you agree that you did, how do we know that that has any connection to an actual risk now or in the future to yourself or others, right? So you were involved in a fist fight, 25 years ago. You've had no further incidents since then. You took an anger management class back then after that happened. You've been happily married. You now work in an extremely stressful field. You're a corrections officer and you're constantly being assaulted and you never react with violence. In my opinion, I don't think that thing from 25 years ago is a reliable indicator of risk now. Another example, cases that I have a lot of success with are people that may have had a substance abuse issue years ago. Oftentimes it's veterans, people that come back and they, maybe they were injured and they end up with, using pain medication in some ways. Sometimes it's guys who had, temporary mental health issues, depression, anxiety, things like that. And they got the treatment they needed, therapy, inpatient counseling, outpatient counseling, whatever it took to get clean, sober, and healthy. Yeah, did they have issues back then? Were there drug-seeking behaviors or were there outputs of, expressions of anger back then? Yeah. But did they fix it? Yes. So again, Chief, how are you using that now when we know that they fixed it and now they're safe and responsible? So that's the other kind of way that we approach these cases. Either way, they're hard, right? Either way, the case law is really stacked against you. The case law literally says that the judge must defer to a police chief's discretion, word for word from a case. So it's very, very hard, but oftentimes the courts will come back and say, look, this guy's been sober for 15 years. He went through treatment. There's evidence that he's clean, evidence that he's sober. It's evidence that he's healthy. The chief is being unreasonable. And then in those cases, we have good results.
How did we get from the Second Amendment to a police chief's discretion in suitability?
Discretion goes back many, many, many years, even before the Gun Control Act of 1998. Now, the Gun Control Act of 1998 made it more clear and added additional prohibiting factors. how do we get from, it's interesting. If you think of it like a pendulum almost, the pendulum kind of swung this way. Now it seems to be swinging back with the Bruin decision. Now there's two cases before the Supreme Court, Rahimi and Range, where the pendulum's swinging back this way towards the Second Amendment and individual right. But I will tell you that Massachusetts continues to hold back in fighting that pendulum swinging the other way. I think, again, how did we get here? It's really a cultural thing, and it's a cultural thing, particularly in this state and, maybe the Northeast, but particularly this state. It's interesting, since the Bruin decision, a lot of courts have analyzed historical firearms regulations, because that's what the Bruin decision talks about. It talks about, is there a historical analog or an example in history that corroborates this regulation? And we start looking at, and there was actually a lot of regulations in early Massachusetts law, regulations about storing black powder, regulations about certain religions not being allowed to have firearms, things like that. We do actually have a long history of regulating firearms, at least in kind of our Puritan society of Massachusetts. And I suspect that this kind of strict regulation comes from that base.
Does license denial based on suitability, does that violate the Second Amendment?
There's definitely an argument to that, and it's definitely an argument that's being explored, and I've explored it to some extent. There's a couple of different prongs to that. There is, as I mentioned, the burden of proof prong. When you have a fundamental right, generally it's the government that is the one that has to prove that they can take it away. I think that piece, that burden of proof, is ripe for the picking. With regard to the rest of it, the discretionary piece of it, again, I also think that's ripe for the picking. And we're now starting to see some other very, isolated lower court decisions, at least two, maybe three, local district court judges have determined that the suitable person standard is unconstitutional as it is currently written. Because of that, may deny a license as being unsuitable. It's subjective, right? And what the Supreme Court has held in the Bruin decision is we really need objective standards. If there may be some version of suitability that is objective and therefore constitutional. It's not the version we have now, but in a version where it clearly spells out this type of conduct. My example, if you've been arrested for domestic violence and there's probable cause to believe you've committed domestic violence, more than twice in the last year, you are unsuitable for this period of time. That might pass constitutional muster, but that is not how our legislature has handled it. That's not how our police departments have handled it. Someday we may get to that point. So going in, it's possible that I'm going to be unsuitable because I've engaged in this kind of conduct. But where we stand right now, until our Supreme Judicial Court, or quite frankly, the Supreme Court, makes a finding that some or all of the suitable person standard is unconstitutional, this is the rules of the game right now, as I described them.
Them being the rules of the game right now, what would you say to someone to make sure that they know how to avoid losing their license?
Mind your manners, mind yourself. Be in control of yourself. What I find, and we're talking about current license holders, what I find is that oftentimes people lose their licenses to carry over just the most foolish things. Getting in arguments with your neighbor over grass clippings going on your lawn, or the dog walking across your backyard, and, flipping out, getting in fights over parking spaces at Christmas, drinking to excess and engaging in arguments with your significant other. Maybe it's not physical, but it's certainly scary, and it's going to cause concerns. And of course, and it goes without saying, obeying our gun laws. And that means, in particular, following our safe storage laws, which time and time again, and hopefully somebody who's listening right now thinks about this, clients constantly leave a loaded firearm in the drawer next to their bed. and they think, well, that's where it should be. That's where I need it if I need to use it. That is unlawful in Massachusetts unless it's locked in a case or locked with a trigger lock or other locking device. And you may not do anything wrong, and the police may still end up in your house. Your house could get broken into. There could be a fire. There could be a medical emergency. There could be some sort of call because there's a loud argument or something coming from your home. There could be a noise disturbance of some sort. These are the types of situations that my clients find themselves in. They didn't do anything wrong. You can't control someone kicking in your window and breaking into your house. And then the police responding before you get home from work and searching the house and finding the gun. Those are the things that, violating our gun laws, leaving a gun unlocked is almost unrecoverable, meaning that if the police feel you're unsuitable, if the chief thinks you're unsuitable because you don't follow our gun laws, how do you fix that? I don't know. Take more classes, educate yourself better, maybe, but really you're going to be at the discretion of the chief at that point. So really being mindful of our gun laws and be mindful of your behavior. Control yourself. In Boston, in this area, you get kind of someone cuts you off in traffic and, you give them the one finger salute. Well, that's great. Well, what happens when that guy cuts you off again and then brake stands you? Are you going to cut him off and brake stand him? And then are you going to threaten him and wave your hand around like you got a gun in your hand? Happens all the time. But those little road rage type interactions can lead to the loss of your gun license because of that behavior. Because it appears that you may be a risk because you can't control your anger and your behavior. Again, you don't need to be convicted of a crime to lose your gun rights here in Mass. So mind your manners and follow the law.
This has been Trigger the Truth, Massachusetts Firearms Laws and Policy with attorney Jason Guida. I'm Sam Henninger. Remember to like, share, and subscribe because we'll continue to have great conversations just like this. Jason, thank you so much.
Thanks, Sam. I appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.